There's some very interesting questions that arose at the end of the last session, and it'd be quite useful, I think, just to take those, especially in relation to how checks are used. Now, yes, it feels like an antiquated, very old-fashioned method of creating money transfers. But in this region especially, the use of checks, and the use especially of post-dated checks, has been a bedrock in terms of fueling credit in the region. I mean, as long as, well, as recently as 5-10 years ago, you could walk into a car dealership, issue 36 checks and walk out with the car, no questions asked. And the essence of that is built on the fundamental criminality around dishonoring a check. And that continues to be the case across this region in the most part, although there is change now happening. So just to take the point about evolution, whilst the technology is producing and going forward at an alarming rate, we have to drag regulation and law behind it in order to catch up. And that's part of what I'm going to talk to you about today. But just, again, not to necessarily labour the point, but to give an example of just the complexity around something like checks. If we look at the essence of criminality around dishonouring a check, what the law in most of the GCC countries states is that the mere fact that you dishonour a check is a criminal offence. Therefore, you could end up in prison, and you don't even have to prove your loss. The mere fact that the check has been dishonoured speaks for itself, or in Latin, it's prima facie evidence. But there also has to be intention as well. Now, the intention when you dishonour a check is obvious. You gave a check, it bounced. However, let's take the example of you buying a car. You've produced 36 post-dated checks. Now, when you wrote those checks in the first instance, did you know that you were going to lose your job in a year's time and then those checks would become dishonoured because you didn't have enough money in your bank account? Was the essential component of intention to dishonour those checks there? Therefore, was it actually a criminal act to dishonour a post-dated check that then matured? These are fundamental questions that need to be addressed in the regulatory environment if law and regulation is going to keep up with the immense change that's happening in the e-payments revolution. I just labour that as a particular point because I know it's particularly relevant to this region. If we look at, just really how... Okay, I think, just bear with me 1 second. Okay, so if we look at some of the models around e-payments, there are many of them and many sort of recommendations about what should be the right model to use. One of the good ones is the BIS ISCO CPSS principles for financial market infrastructure. It has as its first rule, and this is no coincidence, that an FMI, a financial market institution, should have a well-founded, clear, transparent and enforceable legal basis for each material aspect of its activities in all relevant jurisdictions. Now, that's a huge definition and really sort of puts right to the front just how important law and regulation is in the context of both domestic and cross-border payments. Now, the relevance in the practical world of all of this really has to do with the size of the payments. So whereas a concept such as GCC net requires a fairly light touch in terms of law and regulation, when you move to the other extreme and you have, for example, a cross-border RTGS system, suddenly the law and regulation that underpins that system becomes incredibly important because you're talking about massive amounts of cash or money flowing from one jurisdiction to another. So what I've populated in the slides, I'm not sure if it's come out very clearly, are 4 or 5 of the key legal concepts that underpin a solid and reliable payment system, and also has sympathy to this definition of the legal basis. If you permit me, I'll take a few of those in turn. It will sound like a bit of a law lecture, and I apologize for that, but it also is something that, unless you understand the concepts, it's very difficult to apply them to the practical solutions that are being discussed yesterday and today. And one of the things we will look at, or I will look at very briefly, is to build on the legal relationship of algorithms around blockchain and other cryptocurrencies, and how that relates to the law as well. So if we look at probably one of the most important concepts, which is around settlement finality, unless we can be certain that when a payment is made from party A to party B is final, irrevocable, and cannot be undone, then the very basis of your e-payment system is always going to be uncertain and questionable. The knock-on effect of not having a well-founded settlement finality principle can actually completely undermine and destroy the entire payment system. A lot of law has focused on this, and there are a lot of models in terms of how that's being used. But what is the definition of settlement finality? There are many, but really what it means is as follows. It is the final settlement of a payment order is the moment a settlement or transfer becomes irrevocable and unconditional. Alternatively, it occurs when a transfer or settlement cannot be reversed by the counterparties involved or by a third party such as a bank or an insolvency administrator. Now, the last part of that is incredibly important, because if there is a fear that a payment can be reversed or undermined because of a court order or some other kind of regulatory intervention, then the certainty and the legal certainty around a payment then comes under question. That creates risk, and that undermines the value of the e-payment system itself. How have other jurisdictions dealt with this? They've dealt with it through the passing of law. So in Europe you have the EU Settlement Finality Directive. Another example is in Singapore, where they have a Payment and Settlement System Finality and Netting Act in 2002. In the UAE, although this is restricted to DIFC, there is also a UAE Payment Settlement Finality Law as well. We're also aware that there is a payments law in progress in Oman as well, which generally reflects the key principles around settlement finality and other key issues as well. Now, how and why we choose particular kinds of law is massively contingent upon the legal ecosystem that you have in place at the time. So whilst, it's easy to look to places like Europe and say, well, they've got directives for this and they've got structures for that, they have a certain defined infrastructure that makes their way of doing it right for them. That may not necessarily be right for this region. So the existence, for example, of the European Central Bank, the Treaty of Rome, perhaps minus the UK very soon, allows for supranational law, and what I mean by that is it's not domestic law, it's law that sits above each member state. They have an apparatus which allows that law to be enforceable across the member states. We have something similar here through the GCC Secretariat, but it is nowhere near as detailed or as all-encompassing as the European Union apparatus. That doesn't necessarily mean that the EU model is better, it's just different. It also has to accommodate a different profile in terms of the member states as well. So we cannot just simply pass directives here harmonizing laws and regulations. We do have to look at it in a more complex way, and I'll come on to that in a minute. So John raised an important point about how progress from one jurisdiction can be at a different pace compared to other jurisdictions, and that's fundamental to ensuring that cross-border transactions are actually safe to do. So whereas you could have one state that has very sophisticated laws and regulations, you're only as strong as the weakest link. So if you are then transacting e-payments with a jurisdiction where the law and regulation is not as sophisticated, you're going to have connectivity and harmonization issues which are going to fundamentally undermine the integrity of the system itself. And I'll give you an example of that. So one of the other sort of key tenets around making a safe system is enforceability. So if you have a default in one state, is it enforced in the same way as it would be in another state? One of the key enablers, if you like, of systemically important e-payment systems is the availability of collateral and liquidity. So how do you enforce that collateral in one state compared to another? Unless there is consistency, then that collateral is going to be fundamentally undermined, and the ability of the e-payment system to be supercharged, if you like, comes into question. It also massively limits how you can look at things like collateral and liquidity if they are viewed by different states in different ways. In this region, collateral around RTGS, for example, is pretty much limited to government paper. But imagine a situation where you could use credits and receivables as collateral as well. But the exponential rise in regulation at the moment doesn't allow that to happen. But it could if we have a harmonized system that actually works. Another way of ensuring that there is consistency around enforceability such as that is around primary legislation. I'm going to sort of bore you a little bit about what is the difference between primary, secondary legislation, and mere contractual obligations as well. If you think about the hierarchy of laws, in a country, you would have the constitution that sits at the top, which is infallible. No one can change it without huge effort. Underneath that, you've got what we lawyers call primary legislation, so this is statute. And under that, you've got effectively secondary or subsidiary legislation, which is used to implement that law. And then under that, you've got contractual relationships between parties. Now, if we look at the bottom of the pyramid first, contractual relationships are susceptible to being overwritten or overruled by courts. So let's say, for example, you have an institution or a trader in country A is dealing with country B. The institution or the trader in country A becomes insolvent. His or her assets are frozen by the local court. How does that affect the party in country B? There are many permutations of this. What we need to ensure that if payments have been made from A to B, that under settlement finality those payments can't be reversed. And the only way we can ensure that is that the insolvency court or the court in country A cannot interfere with that payment and reverse it. So what we need is a degree of insulation of any payment system that we have. And that insulation generally is best provided by primary legislation. That's why so many jurisdictions have passed payment laws which say pretty much in paragraph 1 that a payment is final and cannot be reversed by any interference by a regulator or by a court. So it has the force of primary legislation, and that's why we have it there. We've talked about collateral and liquidity. Another sort of key area is around conflicts of law, and this is a subset of what we've talked about just now. So again, where you have payments going from one territory to another and a dispute emerges either between the parties themselves or even between the regulators, which law will apply? Which jurisdiction will the dispute be heard? Now again, unless we can create an environment where there is clear definition on that, it's going to create risk. So how do parties deal with that risk? Well, they come to lawyers like us and they say, well, we're setting up these payments. What are the risks of trading with country A or individual B or party C? We will then give them in typical legal fashion a very caveated opinion that says, well, it depends. And not to sort of beat my own profession up, that there's only limited sort of comfort you can take from that. In the absence of that certainty, the risk is then valued, and that manifests itself in cost in terms of the use of the system. In other words, the more risk and the less legal certainty in a payment system, the higher the cost of using it. Conflicts of law, primary legislation can sort of all fix that. We've talked about mitigation legal risk and also insolvency. But there are other legal arrangements that need to be factored into as well. So, for example, linking arrangements between different e-payment systems. What is the law and fundamentals around preventing things like contagion if there is a problem with one of those systems? And our clients tell us that the biggest concern that they have when it comes to creating cross-border systems is linking their own systems to other systems and exposing themselves to the risks that exist in those other systems, either actual or perceived. And again, once you link all these systems, the risk of contagion goes up exponentially, and you could have very serious domino effects if you're not particularly careful. There's also the challenge, if you like, around ensuring that e-payment systems respect and are compatible with Islamic finance products as well. So that kind of interfacing, if you like, is really important as well. You know, could we have a situation where we have intermingling of Islamic versus non-Islamic payments? You know, how is that going to be defined? Will that be permissible under Islamic finance concepts? Part of the design of systems, therefore, you know, has to take into account, you know, all of these issues. So just as a reminder, settlement finality, enforceability, conflict of laws, collateral and liquidity, dispute resolution, and insolvency. So these are all sort of key areas that sort of need to be looked at. As a subset to the legal frameworks is governance and oversight. Now, I don't plan to go into too much detail on this because it is an entire topic in itself that that exists, you know, essentially to provide better sort of security around the e-payment systems. But it is still principle number 2 in the ISCO principle. So again, you know, the fundamental importance of law and governance, you know, can't be understated when you're talking about e-payment systems. So I'll just read it to you. An FMI should have governance arrangements that are clear and transparent, promote the safety and efficiency of the FMI, and supports the stability of the broader financial system, other relevant public interest considerations, and the objectives of relevant stakeholders. What that means is that, you know, we have to have systems in place that are corollary to and ancillary to the legal framework that have things such as oversight committees, oversight of suppliers, oversight of stakeholders, the creation of a regulatory body that has the sufficient sort of tools and teeth to be able to actually enforce proper governance. That includes things like compliance, risk management frameworks, incident management, and things such as security governance as well. So I guess the point I'm making is that even when you get beyond the hypothetical nature of the legal and regulatory environment, you need processes and structures around e-payment systems that provide sufficient oversight and governance to ensure that it works properly. A lot of this has been sort of, you know, looked at before, so there are structures that exist that really do sort of flesh out just what governance structures look like, but I won't bore you with the details of those right now because it does get incredibly technical. So we've talked a bit about sort of, you know, payment laws per se, and, you know, we've talked a little bit about legal hierarchy too. One of the things I'd like to talk about, because it's particularly relevant to this jurisdiction, is supranational law versus national legislation. So if we were to take a broad look at the GCC countries and the laws that exist around traditional payments and how they're being stretched to encompass e-payments as well, there is a broad similarity, they're not identical, but a similarity in terms of the laws that exist. What tends to happen, what has happened, is that through royal charter or decree, central banks have been given powers and mandates to oversee and manage payment systems, including e-payment systems. Overlaid under that are laws around banking codes, commercial codes, and even civil codes as well, which together form the body of law and regulation around which banking supervision is based. But no two states are the same. And when you go further beyond the lower Gulf and you start looking at the wider sort of Arab Monetary Fund member states, then the differences start to emerge in much greater detail. So how do you, if the objective is to create a degree of harmonization so that concepts such as settlement finality are consistent across different states, what is the best way of achieving that? Well, we have the GCC apparatus available to us, and we do see treaties, and some of the lawyers in the room will pick on me and say that, yeah, okay, hold on, the definition of a treaty versus law, versus resolutions issued by the GCC have very different meanings. So forgive me in terms of the terminology, but let's just talk about a body of law coming down from the GCC. It does, in theory, have the weight of binding the individual states, but it doesn't have the political process behind it to give the sufficiency of detail that an e-payment system would require in order to work properly. So whereas the Europeans do have that, and they use that frequently through a directive system, it probably wouldn't work in this jurisdiction. So we have to look at alternative ways of harmonizing law and regulation across the region. At the other extreme, you could look at the local laws of each member state and harmonize them that way. But that's going to be a massively difficult task, and you could have severe unwanted and unintended consequences from going down that path. So one potential solution is a halfway house in many ways, which is to have primary legislation, as described before, which is consistent with the primary legislation of other member states. An example of that is the COMESA model. So to become a member of COMESA, you have to, as a country, pass as a law within your own state a unified digital e-payments law. It's not called that, but essentially that's what it is. What it means is that each member state has to incorporate into its own domestic law a consistent body of primary legislation, which then overcomes all of these inconsistencies that we've seen could undermine an e-payment system. We have a similar system in HKMA, where again they use rules and regulations and primary legislation in order to sort of create that consistency. Just mindful of the time, I'm just going to sort of race beyond that. It is a huge area just in itself, but we've heard about, from other speakers, the sort of use of blockchain, and one of the iterations of that is Bitcoin. So, although I do have a degree in computer systems engineering, blockchain, does concern me, and it absolutely terrifies every single lawyer out there. I'm actually more on the sort of, okay, it's happening, let's deal with it. There are lawyers out there that only realized what Bitcoin was when they were held to ransom on a data purge attack. Blockchain has the ability through encrypted ledgers to revolutionize how law and regulation around e-payments is actually carried out. And it's not just e-payments, it's around transactions generally. And I'll give you a very basic example because that's the easiest way to look at it. Let's think about escrows and payments. So traditionally, if you need a complex escrow arrangement, you'll go to an escrow agent or a lawyer who will then execute release of payment upon the fulfillment of certain conditions. What blockchain allows you to do is to do away with the escrow agent entirely because the algorithms and the technology can verify that a certain event has happened and allow certain other events, and in this case the release of a payment, to happen automatically. So building in effectively a chain of custody and simple contractual fulfillment is what blockchain offers from a legal and regulatory point of view. So the type of things that it could apply to and will revolutionize from a legal point of view are things such as financial transactions, proof of title, whether it's a car or a house or something else, chain of title, which again is massively important from a legal point of view, authentication, you are the person that's actually issuing and executing that transaction. So think traditional signing of contracts that's now moved to digital signatures that actually you don't need those anymore at all. Identity, chain of custody, which is incredibly important from an evidentiary point of view when it comes to litigation. Evidence and discovery, so you imagine, around litigation and court documents. And smart contracting, so where you can have the purchase and sale of goods and even very complex financial instruments done incredibly quickly. Blockchain allows you to build code into certain parts of the block, which can then be executed as part of a transaction. It is a bit of a nightmare for lawyers like myself, but we are trying our best to keep pace with how that actually works. Some of the other disruptors that we've seen and that I've particularly worked on are things such as crowdfunding. So I had a hand in drafting some of the light touch crowdfunding regulations that now exist in the UAE, and how that is sort of changing how peer-to-peer transactions are working, especially when it comes to complex financing, and the fundamentals of doing business, such as shareholders agreements, sharing and equity, and this type of things as well. But specifically, or especially for this region, one of the other major disruptors is around financial market integration. We all know that the closer that financial markets come together, the better it is for trade, the better it is for the economy, and how it can enhance all those things at the same time. But the challenges of bringing these markets together from a legal and regulatory point of view are huge. They're not insurmountable, but they are incredibly difficult and complex to manage. So, in some ways, we as the custodians of the law and the regulation, are the ones that are sort of like, putting the brakes on in many ways and saying, look, allow us to catch up, because unless you do that, the e-payment systems are going to be fundamentally flawed and undermined by uncertainty. So I'm conscious of the time, but I really wanted to sort of delve into the core basic legal concepts, because I'm pretty sure everyone in this room knows more about the complexities and the new developments of e-payment technology than I do. But unless both legal and regulation moves hand in hand with the technology, then one cannot advance safely without the other. Any questions?
Thank you, Waseem, for this presentation. My question will directly dive into the part where I believe we are currently in a situation where those borders are almost diminishing. Mm-hmm. And hence there is also again from the classification that we were using giving into the payment systems, this is the large value payments and this is the retail payment systems and so on. There is now the hybrid part between the two. Mm-hmm. And hence, definitely, since the systems are evolving into this new, let's say, criteria of classification, I believe from the other part, the legislative part also have to take this into consideration. Mm-hmm. In the extreme part of the large value payments, we have the finality, the irrevocability, and so on. And from the retail, we can wait till it's the netting time and so on. How is this being adapted in the regulatory or from the regulatory point of view?
Yeah, so it's a complex answer, so I'll try and keep it relatively simple. Really, sort of regulation is done on a commercial basis. So where you have a light touch regulatory environment is really dictated by the importance of what we're looking at. So if we look at, again, I'll use the example of GCC-Net. Relative to other e-payment systems, the amounts are relatively small. So the risk to the states and to central banks is relatively small. So the regulation around that particular payment system, for example, is actually quite light. Some actually quite frighteningly light, if I may express a view. But as we are exponentially advancing forward with the new technologies, the speed of which payments can snowball and become massive and huge, and the contagion if something falls over is important to look at. So around the world we're seeing a proliferation of more and more e-payments law, and because of the nature of finance, there is a high degree of consistency that's emerging between these e-payments law. So those principles I talked about earlier are the hallmarks of pretty much all of those pieces of legislation. So what we're seeing is a degree of consistency that's now emerging. That consistency will enhance the ability to do to allow the technology to go forward. It's important for each state to have a plan, as it were, a regulatory and legal plan, and that plan has to be not only sympathetic to the local laws and regulations and economics, but also what happens inevitably when those systems connect to wider financial systems in the world. So regardless of which part of the world you're in, you really do have to ensure that you have an eye and an ear in terms of how regulation is progressing on a global platform. Financial market integration is something that is quite far down the road, for example, in Europe. It's something that's being looked at very carefully in this region, and that will accelerate the passing of legislation, primary legislation around things such as e-payments. Thank you.